Welcome to Health Law Simplified. I'm Elizabeth Lippincott. I'm the founding member of Strategic Health Law, and I'm here with my colleague, Sandy Durkin.
Hi, Elizabeth.
Hey, Sandy. Good to see you.
Good to see you too.
Well, today we have interesting, kind of a juicy topic. We're examining a major enforcement action that's shaking up the Medicare Advantage world, along with lots of other things right now. And it's the DOJ's complaint filed on May 1st against three large health insurers, Aetna, Elevance Health, and Humana, alongside three major brokerages, eHealth, GoHealth, and SelectQuote, around Medicare Advantage plan marketing. Can you break down, Sandy, the DOJ's allegations for us?
Absolutely, Elizabeth. You're right. This is a big deal, this complaint. It's a 217-page document, and I actually recommend that lawyers in this space take a look at it, as well as compliance departments, because it was based on whistleblower allegations, and the DOJ had access to internal documents of the companies in this case. And so there's really a lot of detail about what the DOJ thinks was going on. And the basics of the allegations are that from 2016 through 2021, DOJ alleges that these plans paid hundreds of millions of dollars in illegal kickbacks to brokers in exchange for enrolling Medicare beneficiaries into their Medicare Advantage plans. And commissions to agents and brokers are very standard. That is how MA organizations sell their products. But according to the complaint, these were not standard commissions, but rather the payments were structured to specifically incentivize the brokers to push specific plans, even if those plans were not suitable or in the best interest of an individual beneficiary. So, if you read the complaint, the picture that you get is that brokers were financially rewarded for steering seniors toward plans from the insurance companies that offered the highest kickbacks. And then the way that the brokers would incentivize individual agents and producers is they would create dedicated sales teams that could only sell plans from high-paying insurers, and they would pay bonuses to agents for steering those beneficiaries into those specific plans that were offered by those insurers. And then some brokers even refused to sell plans from insurers who couldn't pay them enough, who couldn't reach that threshold that these larger national insurance companies were alleged to be paying.
Wow, those are serious allegations. And one thing that jumps out at me is just the idea of a False Claims Act whistleblower in the sales channel context. So when you think of whistleblowers and Medicare Advantage, you think risk adjustment, maybe, maybe MLR issues, maybe sort of things that have to do with the level of payment coming from the government to the plan. This is a new one to think about the whistleblower risk in the context of your marketing and sales of your plans and the downstream contracts in that space and the employees of those, agencies. And it's kind of a new world of risk, potentially.
That's a really good point. I believe the whistleblower in this case worked for one of the brokerage companies, not a plan. And that surprised me. The way that the dynamic often works is that it's these large vendors, and all of the defendant brokerages named in this complaint are large companies who are pushing the MA organization, which has they all have extremely robust compliance programs and structures in place. So often it's the vendor that's pushing for marketing arrangement that's maybe a little more in a gray area or a little more cutting edge, carries a little more risk. And they'll tell their potential customers, oh, everybody's doing this. But what a plan doesn't know is maybe there's a whistleblower inside that organization and you could get in trouble for their conduct.
Yeah. And just before we're going to get into the meat of the allegations, but My sense with whistleblowers, of course, there's a financial incentive. It's huge. But I also think there's often just a person that was getting pushed to do something that didn't feel right to them. Whether it's a nurse practitioner doing in-home assessments or somebody coding those notes from those assessments, or it's somebody working in a brokerage saying, oh, push these plans. They're the ones who are getting paid more, which is what is alleged here. So it's just an interesting dynamic. Speaking of the allegations, there is also allegations of discrimination, at least against some of the defendants.
Yeah, this is another interesting wrinkle to this case. So, the Department of Justice alleges that two of the defendants, Aetna and Humana, not the Elevance defendant, conspired to discriminate against disabled Medicare beneficiaries. So, those folks were eligible for Medicare by way of disability, not age. And the reason why is because those beneficiaries were perceived as being less profitable for a health plan. So, what the complaint says, again, these are all allegations, is that these insurers pressured brokers to enroll fewer disabled individuals and made their payments, these alleged kickbacks, conditional on the enrollees in the plan being so-called age-ins versus the disabled beneficiaries. And then the brokers, the way that they carried that out allegedly is that they would reject referrals of disabled beneficiaries, or disabled beneficiaries would call in and they would either be turned away or directed away from the Aetna and Humana plans and pushed into other plans. So essentially, if you take all these allegations together, it's that the defendants were prioritizing profit over patient need, which of course undermines the very purpose of Medicare Advantage.
Mm. Well, what are the legal implications for the plans in particular that are named in this case?
Yeah, that's a good question. The implications are quite significant aside from the litigation costs. This case is being brought under the Federal False Claims Act, which is a very powerful tool that allows the government to pursue any individual or organization that defrauds federal programs. So, the Department of Justice's theory is that these kickbacks distorted the market, undermined patient choice, and led to the submission of false claims to Medicare. And if the government is able to prove its allegations, the penalties will be enormous. The False Claims Act includes triple damages and civil penalties that apply for each and every single false claim. A false claim is basically a claim for payment to the government. So every payment that a plan received for an individual that the government contends was improperly enrolled into one of their plans is a false claim that's tainted by the anti-kickback violation that led to that enrollment and will be tripled and then multiplied and could result in millions of dollars of damages.
Have we heard responses from the plans to any of the allegations yet?
We're very early in the litigation. Litigation is slow, so we do not have formal answers. All three insurers do deny wrongdoing. And in statements, Aetna and Humana have said they're reviewing the complaint. They do intend to defend themselves. And Elevance has not issued a detailed public response at this point.
Hmm. You did a careful read of the complaint. Was there anything that surprised you?
Yes, it was. Again, I wouldn't be recommending it if this were a boring complaint. There's a lot of detail in here. The Department of Justice had access to internal communications that were going on within the brokers and then between the brokers and the insurers. And as somebody who represents a lot of plans and has worked on marketing arrangements with agents, producers, some of the conversations that were going on, especially at the broker level, they would have given me a heart attack if I was a compliance officer or an in-house attorney at one of these companies. So just as an example, when discussing its marketing arrangement with one of the plans, one of the eHealth executives joked that the plan was paying eHealth $15 million a year for a website that only drives 15 enrollments per year. So the allegation is really that that was like a sham payment that was actually for enrollments. And then in this correspondence, the executive said, CMS will surely never figure that one out. Luckily, the government are generally morons. That's not the culture of compliance that you want your
Yeah.
vendors putting in writing, at
But
least.
if nothing else, however this turns out in final legal analysis, there's a lot of room for growth in some of these companies just to have these kinds of thoughts documented. And we're here, by the way, at Strategic Health Law, if anyone would like advice or assistance with compliance training, compliance, we call it consciousness raising, just having people understand how important it is and how carefully they need to choose their words.
Yeah, that's a great plug, and
Yeah.
a preview for some of our takeaways for
Yes.
for companies that are following this litigation. Just as another example, the language in the complaint is a little more colorful than I'm going to say here, but when discussing Aetna's agreements, another eHealth executive wrote that the payment model was, quote, not even a little compliant. I'm pretty sure that if Aetna got audited by CMS, they'd be screwed. And yeah.
The word started with an F.
Yeah.
Yeah. This is a family program, but yeah. And just the idea that an executive is writing that down is kind of amazing. um,
Alarming.
yeah. I haven't heard of a lot of like FMO audits, especially now that there isn't a formal requirement of a compliance program or plan or, well, there's training requirements for agents, but a lot of room for growth here in terms of whatever the underlying conduct is, just the way things were discussed and put in writing is really not helpful to these companies.
That's a really great suggestion. Yeah, I think typically the oversight of agents and brokers is done through CMS secret shoppers, through the complaint tracking module. But even if CMS isn't auditing these companies, there's no reason that a plan can't be. I think that in this environment with this lawsuit on record now, there's a lot of reasons for plans to dig a little deeper,
Yeah.
and beef up the training so that it's not just about those marketing and sales rules, but really gets into the risks and the responsibilities that apply when you are working in federal programs.
Yeah, totally agree.
I did want to comment on one other surprising aspect of this complaint, and it's that the contracts that were in place between the brokers and the plans named in this lawsuit during the relevant time periods, they were structured very carefully in a way so that if you were just looking at the papers, they would look like they comply with the anti-kickback statute. The contracts included acknowledgments that the brokers would be paid with federal funds, statements that each of the parties would comply with the anti-kickback statute and the False Claims Act. They did not include any language that would suggest that payment was conditioned on volume of plans sold or enrollments. There was no contractual language about limiting sales of competitors' plans. It did not look like the plans were paying for sales. It looked like they were paying for marketing. And in the complaints, the Department of Justice actually uses that as at least rhetorical evidence against the plans, citing this contractual language and citing internal codes of conduct as evidence that the plans knew that their conduct was illegal.
So, Sandy, is there law on the books that Medicare plan, broker commissions, or other payments can violate the anti-kickback statute?
I'm going to have to give you a lawyerly answer, Elizabeth. Is there a law on the books?
Or common law cases.
There is, I'm not
Holding.
aware of any major case that has definitively held that agent and broker commissions violate the anti-kickback statute. There's not a clear law we can point to that says this type of payment is illegal, or a case that's looked at this set of facts before. But the idea that these types of payments could violate the anti-kickback statute, it's not new. And although I was surprised by many elements of this complaint, I'm not surprised by the fact of this lawsuit. So hearkening back to 2024, which feels like a lifetime ago, CMS issued a rule, or tried to issue a rule that we're not going to get into, but it was putting some new rules in place for broker payments. And in the preamble to that rule, CMS made a statement about how excessive payments to third-party marketing organizations could violate the anti-kickback statute. And that was, I know when we saw that was like a little red flag telling us, this is what CMS is concerned about, and these are the legal risks to plans. And then the Office of the Inspector General, which is CMS's watchdog, has been looking at compensation structures that it deems excessive for a few years now. So examples of potentially risky compensation structures that OIG has been looking at would be, any payments that are above fair market value, bonuses that are tied to enrollment targets, or compensation that's linked to health status or profitability of an enrollee. So CMS has been looking at these. DOJ has been looking at these. There's been some investigations in the news over the last few years. And then all of that culminated in a special fraud alert that OIG put out late last year, warning that broker compensation arrangements in Medicare Advantage could implicate the anti-kickback statute. So we did have that warning that this was a possibility.
Well, and it's also interesting looking at it from a political lens, because that sort of commentary about the anti-kickback statute being implicated by excessive payments to brokers, that was in the preamble to a rule, drafted under the Biden leadership at CMS. And then we actually had a client forward us another law firm's public white paper that these other lawyers had done an analysis and concluded that the anti-kickback statute did not come into play with broker payments for Medicare Advantage plans. And we had to say, we respectfully disagree with that. But that was sort of floating around. And then it's interesting now, I'm spilling a little legal interpretation tea. I won't name names, but and then now we're seeing several months into the Trump administration, the DOJ, kind of after having this investigation going for several years, because some of these brokers, or at least one of them, was referencing it in its securities filings, filing this pretty significant complaint in this space. So it seems like it is definitely at least a significant risk, and this administration is serious about pursuing it.
Yeah, this is one area where there seems to be true bipartisan agreement. There is, everybody knows that the current administration is really going after fraud, waste, and abuse in any and all forms. And the Biden administration, the CMS under Biden's administration, really laid the groundwork for CMS and OIG, the Department of Justice, to aggressively go after Medicare Advantage organizations who they deemed were not being careful stewards of government money. And I think this lawsuit is just an indicator of more to come.
Yeah, so interesting. So what are your thoughts on what plans should do at this point with this information? Other plans, I'm not talking about the defendants, but this is out there. We also have, I'll just try to give a brief recap of in 2024, CMS put out a rule to be finalized for the 2025 plan marketing season that would have curtailed the ability of plans to pay amounts above their standardized commission amount to compensate brokers and agents and field marketing organizations. FMOs is one of the terms that's used for the large agencies, for administrative services. There had been an allowance for fair market value payments for services above and beyond the fixed or capped commission amount. And CMS in that rule allowed a larger commission amount to account for its very modest estimate of what those services were worth. There was litigation from the broker community, and a federal judge stayed that rule, and that litigation is proceeding. So that has been stayed. But anyway, there's sort of this backdrop. So the previous rule where these extra payments capped at fair market value are permitted, that is currently the law of the land. But what do you think, like in this mismatch, now that you have all of that, and then you have this complaint, what do you think plans should be thinking about right now?
That's a really great question. I do want to thank you for taking the time to revisit that complicated broker compensation rule, because I think when the court stayed that rule, a lot of folks in the industry, plans, brokers, other participants kind of breathed a sigh of relief and thought, "We're out of the woods on this one. We can keep paying our administrative fees and our marketing fees to our third-party marketing organizations with relatively little legal risk." And I like it when thought leaders, reporters, et cetera, will say, will point out when they're wrong. I think at the beginning of this administration, I predicted that the Trump administration is going to let the legal challenge to that broker compensation rule die in the courts. They're not going to vigorously defend it. And now, even though I don't think that rule is coming back in the form that CMS tried to put it out in, I do think, this lawsuit tells us that there is going to be more effort by CMS and OIG to scrutinize and regulate broker compensation. So your question is, what do plans need to do? I think you need to dust off those third-party marketing organization contracts, contracts at all levels, right? From the smaller brokers to the large companies, and make sure that they comply not just with current CMS regulations, but make sure that they don't raise any anti-kickback statute risks. Make sure you have done a fair market value analysis and that that's on your books, so that you can point to that as a defense of the payments that you're making. Another thing you're going to want to do is, look at details like, are your payments to a third-party marketing organization structured so that they only go out after the rapid disenrollment period has passed? That was an issue in this litigation that we've been talking about. And the Department of Justice alleged that suggested that the payments were actually tied to enrollment because the brokers were not getting paid when an individual rapidly disenrolled. That suggests that the payment was for the sale and not for the marketing work that the brokerage was putting in that led to that sale.
Hmm.
You'll also want to look at details like, do your contracts allow brokers or third-party marketing organizations to funnel the payments that you as a plan have given to individual agents as bonuses for enrolling in your plans? Are there financial incentives, on paper that would cause an agent or a producer to steer members towards your plan regardless of the beneficiary's best interest? So these are all potential risky terms that you're going to want to make sure are not creating unnecessary risk for you.
Something that I would want to see if I were an internal auditor or a compliance officer for a plan right now, and maybe done under privilege. There are pros and cons to that. I would want a review of, on one side, the contracts in place with brokerages of all types, including these large and small, and then an analysis of the payments going out to those, and do those match up? And were the contracts driving those payments reviewed by health lawyers? because the way some of the contracts are described in this complaint, and of course, a complaint it's an advocacy document, you take it with a grain of salt, but the way they're described, I would be surprised if they had rigorous legal review. I mean, some of them go beyond the standard types of producer agreements that we see, even, including the ones that include those administrative overrides. So I do think that it would be advisable to at least make sure you know what has been happening with your company, just to be able to evaluate potential exposure and evaluate at the appropriate level of seniority. Does what's happening align with your risk tolerance, knowing what's happening right now in this space?
Yeah, that would be a very useful analysis to have. And then building on that, you know, this complaint tells us that it's not enough to have a compliant contract.
Mm.
My view as outside counsel is that more oversight is needed of planned marketing efforts by legal and compliance departments. When we advise on risk adjustment, we always say, ideally, a lawyer would be looking at all of your communications about a risk adjustment program, particularly when you're in the sales phase, negotiating with a vendor. You want to know what vendors are saying to your salespeople and what kind of, or your business people at a plan, and what kind of risk they could be creating for you. So I think here, plans want to know what the sales team is saying to brokers when it's negotiating with them. It's alleged in these cases that the payments in question that violate the anti-kickback statute were not for marketing or administrative services, but were for enrollments. So what does your business team think it's paying for? Does it think it's paying for enrollments? If so, that's a problem. What does the broker or the vendor think that they're doing for you? Do they appreciate that they're being hired to provide marketing services or administrative services, or do they think they're getting paid for enrollments? So you need to know what's being said. You need to be looking at those presentations that the brokerage companies are giving to your team, the graphs that show what are the metrics they're going to be tracking. Are they going to be tracking sales and enrollments or something else? And then if there are problems there, that's where training comes in. Your internal team at a health plan needs to know how serious this kind of conduct could be. And then you also want your business partners to understand. So there may be training needed there too.
I think also this complaint could be used as leverage in discussions, especially by smaller plans that we know from experience get jerked around by some of these broker organizations, that you truly cannot sell enrollment. You cannot require kickbacks to steer people to particular plans, and you need to be selling our plan on the same terms, and you can't ask us for these things. And and you could have that conversation not just with these defendants, but in general. Because I do feel like the plans with, we'll put it politely, with the lower risk tolerance really are at a disadvantage when things like this are going on, potentially.
Yep, that is one silver lining of this lawsuit. It's going to put pressure on the broker part of the industry to develop that culture of compliance that health plans have, had in place for, since the outset.
And then the other question is there a way in looking at contracts, not just for, state of the union right now, what do you have in place, but thinking about some of the things that we do routinely with other types of more operational vendors? Is, do plans need to put provisions in their indemnification clauses, being really specific? Look, if we have legal liability as a result of your conduct, you will reimburse us our losses really specifically. And in some of these things, with the anti-kickback statute, it takes two to tango. But what's reading between the lines of these complaints, there are situations where it sounds like the broker, from a legal risk standpoint, is really throwing the plans under the bus. It's just a whole new world of thinking about this kind of whistleblower exposure coming from your broker contracts.
Yeah, that's a really good suggestion. And another area where plans may want to exercise more oversight is in the marketing by these third party marketing
Mhm.
organizations. So, a lot of the marketing they do may not be specific to your plan. It might be very general about their brokerage services. But if a TPMO is saying, we're going to put you in the best plan for you, and then their practices don't reflect that reality, that they're truly acting in the beneficiary's best interests, they're actually steering to plans based on compensation, that's a real legal risk. So it's a good idea to look at what those organizations are submitting and filing with CMS and make sure that it's consistent with, with the practices and what your expectations are of that organization.
Yeah, it was interesting. And of course, these are just allegations. But when I had heard steering, we've been following the rulemaking on this for a long time. I thought of steering more as all things being equal. Are you steering to one based on your compensation as the broker? And the way the allegations are structured and described here, it's really steering to plans that are objectively worse for the person. And that just reframed that for me a little bit. In some of the rulemaking, I thought maybe they're being a little too idealistic about how the world works. But here they at least are alleging that there was clear understanding that something else would be better for the enrollee, and they were being steered to something only because the brokerage would receive a larger payment from that carrier. Who knows what the truth is, but that's what's being alleged.
Do you have any other suggestions for what plans can do, in recognition of the fact that there might be more oversight by CMS and OIG on marketing issues?
I would recommend setting up discussions with your broker community and particularly these larger broker organizations and say, please report to us what you are doing in response to this, how you are taking steps to ensure compliance. What are you doing to, manage these risks, to train your folks, whatever, and to let them know that, you expect them to be responding to this development in the legal risk environment.
Yeah, that's a good suggestion. One thing that we saw after the final rule that CMS tried to implement last year, is that the industry was very quick to try to get out in front of regulation that directly impacted them. They were talking to plans. They were making arguments as to why the rule didn't apply, and eventually they filed a lawsuit. So I am certain that at least the larger companies are very aware of what's going on and are prepared to address questions.
Yeah, I agree. There's just a lot going on right now for the same pool of people doing the work. You have the risk adjustment audits, which we'll talk about on another call. But yeah, there are a lot of demands on their time in a constrained resource environment. So it's challenging to run an MA plan right now.
That should be our tagline. It's challenging.
It's challenging. Yeah. Well, thanks. I've enjoyed our discussion.
Yeah, really interesting. We'll be monitoring this case, and if there's any big updates, we'll let you all know.
Yeah, always a pleasure, Sandy.
You too.
If you enjoyed this episode, please subscribe wherever you get your podcasts. And if you want to find out more, go to strategichealthlaw.com. This podcast is for informational purposes only and should not be considered legal advice. If you need legal advice on any topic we've covered, please consult an attorney with appropriate experience in health law. Our music is Galaxy Love by Johnny Duke. Until next time, thank you for listening to Health Law Simplified.